So news broke last week that the ATF is preemptively enforcing their final rule on frames and receivers, and that they shut down JSD Supply because that company was selling 80%ers and parts on their website. Well, JSD Supply just filed a lawsuit against the ATF. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank one of the main sponsors of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So take it from an attorney. One of the best things you can do is having a membership. I have a membership through USCCA as well. I paid for it for myself. I've had it for a long time. And one of the worst things you can do is not prepare for what happens after a defensive shooting. And the litigation can be the worst part. So USCCA will help you through all that, along with giving you a ton of training and education. So if you're interested, you can use the links down below. And thank you again, USCCA, for sponsoring this channel. So like I said in the intro, last week, the ATF shut down JSD Supply for selling 80%ers and other parts on their website. News broke last week that the ATF served JSD Supply a cease and desist letter, and as a result, JSD Supply had to temporarily shut down their website. One critical thing that came out of this cease and desist letter from the ATF is the fact that the ATF is now of the position that a company who sells 80%ers and other parts on a website without an FFL is in fact violating the GCA. The ATF claims that if a company sells 80%ers and various parts on the same website, that is a violation of the GCA, and they also claim that it doesn't matter if a company sells the items in a single transaction or even in multiple transactions. The ATF claims that if a company simply has all these items available for sale, then it is selling firearms as defined in the GCA, and to do so without an FFL is a violation. Now, the cease and desist letter comes on the heels of the ATF releasing their final rule on frames and receivers about a month ago. Under the new rule, gun stores, FFLs, now will have to serialize 80%er kits, and they will have to do that for every single 80%er kit that they have in their inventory. On top of that, they will have the responsibility of running background checks on individuals who purchase these items, and once this rule goes into effect, they will have to start instituting that. So going forward, the effective date is in about mid-August. So for those individuals who purchase 80%ers in August on, there will be a background check run on you, fingerprinting, all that stuff, and also those 80%er kits will need to be serialized. Now, you might have heard me say just right there that this rule is supposed to go into effect in mid-August. That is because the rule is not effective until 120 days. But the ATF, through this cease and desist letter to JSD Supply, is already trying to enforce this new rule, and they're trying to enforce something that's not even actually conceived of in their new rule. Now, since I put out my last video on this issue, there are a couple of significant updates. First, JSD Supply's website is once again up and running. I don't know for how long that will be, but after I put up that last video, their website went active once again. Now, another major thing that happened, and one of the most significant things I want to talk about in this video, is that JSD Supply has filed a lawsuit against the ATF. Along with their complaint, they also filed for a temporary restraining order, or a TRO, against the ATF, and they also filed for a motion for preliminary injunction. In their complaint, JSD states that defendants, the ATF, vague cease and desist order without any statutory authority has forced plaintiff JSD Supply to immediately suspend all retail sales of its entire product line, causing immediate and substantial financial losses, violating the Fifth Amendment, and infringing on the Second Amendment rights of plaintiff and its customers. They also argue in their complaint that the ATF has specifically and repeatedly explained that firearms parts such as barrels, triggers, springs, etc. are not firearms under the federal statutory law, including the GCA, and thus are entirely unregulated by the ATF and unable to be regulated by ATF absent an additional grant of statutory authority. Even more so, the ATF has specifically and repeatedly determined that the 80% frames and receivers which plaintiff sells are not firearms under the GCA and thus are entirely unregulated by the ATF. However, the ATF's issuance of the cease and desist order to plaintiff represents the most recent iteration of ATF's secret and unannounced policy changes about 80%er frames and receivers. So the complaint by JSD Supply can really be boiled down to a very basic but factual argument. There is a plethora of ATF determination that parts are not firearms and therefore are not regulated under the GCA. The ATF has always been of the position that barrels, triggers, springs, all of those parts are not in fact firearms and are not regulated by them. Also, there are a variety of determinations by the ATF that 80%ers are not firearms and therefore not regulated by them under the GCA. However, the ATF once again secretly changed their policies and determined that selling parts and 80%ers is a violation. And of course, it is reaching all of these determinations and rule changes without statutory authority. Now, JSD Supply also filed a motion for an emergency TRO and for a preliminary injunction. A TRO is an order by the court immediately prohibiting a threatened action. A TRO is only issued when there is a threat of irreparable harm that will occur if the court doesn't immediately issue that order. Now, one important thing to note is that a TRO will only last until a preliminary injunction hearing takes place. So think of a TRO as an immediate stopgap to prevent the ATF's actions until the court can hear this larger and more important preliminary injunction hearing. In contrast to a TRO, a preliminary injunction is an order prohibiting an action to preserve the status quo while the underlying court case is being decided. Preliminary injunctions generally last until the end of a lawsuit. So a TRO is a quick relief to prevent the ATF's actions until a preliminary injunction hearing takes place. And the preliminary injunction itself is granted to prevent the ATF from engaging in this conduct until the actual lawsuit is resolved. So that's a quick explanation of the legal mechanisms that are at play right now. In reaction to those motions, the district court actually has already issued an order, and in that order they denied the TRO, but it did grant a hearing for a preliminary injunction. In denying the TRO, the court stated that, importantly, TROs are ordinarily aimed at temporarily preserving the status quo. Under federal law, TROs should be restricted to serving their underlying purpose of preserving the status quo and preventing irreparable harm just as long as it is necessary to hold a hearing and no longer. The court goes on to state that plaintiff acknowledged in their emergency motion that it has complied with the cease and desist order from the ATF. Therefore, the entry of a TRO, always an extraordinary remedy, is not necessary to maintain the status quo before a hearing may be held. However, the court said that it will proceed with alacrity on the motion with respect to the request for a preliminary injunction. Alacrity is your $100 word of the day, which means with cheerful readiness or willingness. So essentially, the court is saying that they are more than willing to hear this preliminary injunction and see if one is necessary in this case. And on that basis, they establish that a hearing will take place on a preliminary injunction, and that will take place next week, May 25th. So that is currently where this situation stands. The ATF is preemptively applying the ATF's final rule before the 120 days. And they are taking the position that a company is in the business of selling a firearm if it sells 80%ers, and then it also sells other parts that could finish a build. And it doesn't matter if the sale takes place during one transaction or multiple. They are saying it doesn't matter at all. To that end, JSD Supply has sued the ATF and is seeking a preliminary injunction to stop the enforcement of the cease and desist against them. The hearing on that injunction will take place next week. So as we get more information, I will definitely let you all know. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So thank you so much for all of your support. Also want to mention that a lot of you were asking me about the second YouTube channel that I mentioned in my last video. Yes, I do have a second YouTube channel. I will link it down below. And over there, I put some different type of content over there. So if you're interested, you can check out that channel as well. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is with Built by Arms Scholars, and this nation we maintain by Arms Scholars.